The publications in the Government Gazette and newspapers circulated in the areas in question were clearly, in my view, adequate to inform interested persons of the proposed toll declaration. The argument that such notification was inadequate and therefore unfair rests on the erroneous assumption that each and every user of the proposed toll roads has a right to be informed, given the importance of the knowledge of the proposed expenditure of the scheme and the proposed tariffs that would be levied in due course. Consequently, this ground of review must also fail. Lastly, Section 25 of the Constitution, unlawful deprivation of property. This ground of review, as I understand it, is that toll levies collected from motorists travelling on the declared toll roads and also future toll roads which might come into existence in the process of expansions of the roads infrastructure will amount to an unlawful deprivation of property as is referred to in Section 25 of the Constitution. There are two answers to this contention. Firstly, such deprivation can only take place unlawfully if the toll road scheme is unlawful. Secondly, the payment of toll levies will take place in terms of an act of general application, being the Sunral Act. I have already concluded that the GPIF scheme is lawful and that the toll road declaration in issue in this application have not been shown to be reviewable on lawful grounds. Consequently, this ground of review or objection must also fail. Finally, shortly before the commencement of the hearing of this matter, an interlocutory application was brought by the applicants against inter alia the first respondent, in which disclosure and the provision of copies of certain documents referred to by respondents in affidavits which served before the Constitutional Court was claimed. That application did not proceed. I do not think there was any merit in that interlocutory application and that it was wisely abandoned by the applicants. Nevertheless, the applicants should bear the costs of that application. I make the following order. 1. The application is dismissed. 2. The applicants are jointly and severally ordered to pay the cost of the respondents, excepting the 6th respondent which did not take part of this hearing. 3. The applicants are ordered to pay jointly and severally the costs reserved by the Constitutional Court to the respondents who participated in that appeal before the Constitutional Court. Fourthly, the applicants are ordered to pay jointly and severally the costs of the interlocutory application, which was abandoned to the respondents to that application. Lastly, the cost orders above include, where applicable, the costs consequent upon the employment of 3 counsel. I hand down the judgment.